My lord, the matter is that, my lord, the petitioner had preferred. What do you want? My lord, I am for the opposite party. My lord, I have no objection to the prayer of the petitioner. My lord, what do you want? My lord, can it be taken up in the mentioned matter? Because, my lord, my visitation rights have been affected. I am for the opposite party, my lord.
No. Yes.
My lord, be updated and be included in the. It is in the monthly list, my lord. Can it be updated in the daily?
I have said upgradation. Please mention the urgency. Hand over the slip.
My lord,
I've told you.
My lord, I am mentioning one matter, my lord. Item, my lord, 612 of the combined list. It mentioned, my lord, in application for interim order, extension of interim order was there, but it is appearing under the heading, my lord, listed motion. Let it appear, my lord. Under
When the interim order expired?
Interim order was passed on, my lord.
When did it expire?
It was expired in the month of November. Thereafter, your
Let it appear under the heading motion. No, you have to file an application either.
Already I have filed an application.
ওইটা application দিয়ে দেবেন তো
Let it appear under the heading application.
Lordship, may I be permitted to mention, my lord, this is the extreme and exceptional case.
What do you want?
My lord, I want hearing, my lord, because
Upgradation.
my lord, already running in the monthly list, my lord. One double
What upgradation?
Lordship.
Lordship, urgency, please hand over the slip.
It is extreme. Widow, woman, my lord.
I am considering each and every mentioning slip.
Kindly, my lord.
Verify from my officers.
Kindly, my lord.
Please mention the urgency and hand over the slip.
Extremely, my lord.
I will consider that.
I'm mentioning one matter for expeditious disposal, my lord.
Please,
2002.
it's appearing in the list.
Yes, yes.
So why are you mentioning for upgradation?
2002.
Expeditious, maybe expeditious hearing. Don't mention for upgradation. I'm requesting you, don't mention for upgradation of expeditious hearing matter.
2002.
Maybe.
At 200 times.
Then I will follow strictly the Honorable Supreme Court's direction in all these matters. If you mention for upgradation, then I will strictly follow those.
Indicating urgency, I shall hand over the slip.
Please don't mention for upgradation of expeditious hearing matters.
My lord, may
I'm requesting you.
my lord, may I be permitted to mention, lordship, online? Online. Lordship, there is a revisional application of 24. It's not appearing in the list, and I filed an application that is also not appearing in the list. Even for once, it is not heard, lordship, from last 8 months. So I'm giving the CO number and K number. If lordship can direct,
ask any of your juniors to hand over the mentioning slip.
Yes, lordship,
may I also be permitted to mention, my
lordship.
lord, this is a matter, my lord, inclusion, my lord. That matter has gone out of list, my lord. I could not reach, my lord, on time, my lord, when the matter was called, my lord. My lord, I have already handed over the slip.
Out of list.
My lord, January 2025, my lord.
Yes, hand over the slip.
My lord, grateful, my lord. Grateful, my lord.
Yes, Mr. Chakraborty. Mr. Chakraborty, Kaka is there.
My lord, I am waiting. I am the petitioner. Opposite party has given me a notice to mention for extension of my interim order. So I am waiting to see, Lord, who will mention for extension of my interim order that I obtained.
105 running in lordship. That is a matter where the argument has been closed and fixed for delivery of judgment on 21st. Considering that, my lord was pleased to fix this matter on 17. Service has been affected. Now it is 105. My lord, 21st will be the judgment will be delivered.
Mr. Rai, please wait. Further upgradation?
No, it has. That is why my lord was pleased to fix it on 17.
That is why it has been under upgraded matters.
105, my lord, if your lordship kindly consider. Otherwise, my lord, everything. Excess.
Mr. Rai, further upgradation is
that is other. My lord has refused to pass an interim order on the ground that it will be
21st.
21st. I am not disturbing 105.
105. Let me see how far I can proceed. এটা একটু নোট করে রাখুন 105 হচ্ছে 21 তারিখে
21st. That is why your lordship was pleased to fix 17th without granting any interim order. I will not pass an interim order because I will take it up prior to 21st. That is why my lord.
Yes.
I mentioned one in-chamber matter which was not taken up for interaction. Not by your lordship, the previous bench, my lord, interaction with the child. Matter was taken in chamber and the honorable court interacted with the child. It was fixed for order.
You can release this, you can.
No, I don't want to go. I want to.
Then I have to hear Mr. Banerjee. I'm not on that chamber. If you want to insist that, I can release that. You can pray for the assignment of that matter because without hearing, I will not interact.
No, the interaction part was over, but only the order was to be passed regarding.
Then, Mr. Banerjee, if you want, I can release this matter.
No,
Because substantially, His Lordship has interacted with the
Lordship,
child.
see the order, my lord. It was fixed, my lord.
Because Mr. Banerjee, I have not interacted.
My lord.
I have not seen the papers.
Yeah.
So I cannot pass any orders. It is to be heard afresh. If you want that, it will appear.
Then,
Or
my
if
lord,
you want,
the mother is suffering, my lord. They'll not let it appear as to be mentioned, my lord, because
it is appearing under.
under, my lord, monthly list of March 1436. It is appearing as not a motion.
Yes.
The motion.
Mention the urgency, hand over the slip.
I'll mention, you know. Because I was, since it was fixed, my lord, for orders, I was saying if it comes under
Orders,
that.
Mr. Banerjee, I cannot direct for orders because I have not heard that matter. If a matter is substantially hard, I can fix it for orders. I am fixing those. But I have not heard that
It
matter.
was not heard by your lordship, but the previous bench interaction not took place.
Yes, but I do not have, I have not interacted with the child. I do not know what is the matter about. If you want, I can release that. You can get it assigned before His Lordship.
Then I'll try, my lord, because the mother is suffering, my lord. Late appearance to be mentioned, my lord, then I'll try before His Lordship. Because His Lordship not heard the matter, interacted with the child, only the order was to be passed.
It to be mentioned at the other one.
Lordship may be permitted to withdraw. Withdrawal. Two matters, withdrawal.
Yes.
Your Lordship,
Yes. For what? Karmakar, no further upgradation. What warrant will be issued? What is the item number? 66. 66 to mark for that. 66 105.
Your Lordship, with regard to item number 102, Your Lordship, my Lord had directed me whether my Lord had any difficulty or not. My Lord does not have any difficulty. My Lord, 20th is the date in the trial court, Your Lordship. Amendment has been allowed. They have filed their
Nothing will
amendment.
happen.
My Lord, the nature and character of the suit has changed. It was a declaratory suit. Now they want cancellation
You
of
are the
the deed, Your
defendant
Lordship.
or the plaintiff?
I am the defendant, Your Lordship.
You are the defendant.
Yes, Your
So
Lordship.
plaintiff has, you have filed your additional written statement.
No, Your Lordship.
File the additional written statement, take all the points.
The 20th is the
Nothing will happen. Yes.
Permit to mention for extension of interim order.
When it is expiring?
Expired on 31st December. I filed an application, Your Lordship.
Application, under the application, it will appear.
May be
The application heading.
may be permitted to mention the matter, my lord. My lord, can application has filed on
Please hand over the slip. I have said applications, please hand over the slip. You did not mention.
my lord.
Applications, please hand over the slip.
Mention, my Lord.
Yes.
Extension of interim order, my Lord, the
When it is expiring?
there was the interim order extended.
Has it expired?
End of the February.
In February. Have you filed any application?
We have mentioned on the.
Then it cannot appear under the extension of interim order. Yes.
Interim order expired on 10th of this March.
10th of
March.
it expired. Why did you mention earlier?
My lord, already I filed the application.
You have filed the application?
Yes.
Application heading is third.
May,
So I have said applications, please hand over the slip. Why are you mentioning?
I mentioned on the 27th February, my Lord, before the expiry of the.
may I have your lordship's leave to mention monthly list?
If it has been mentioned, kindly verify. Those which have been mentioned, I have directed, which was expiring, all the extension of interim orders.
Monthly list item number 590 for upgradation. Your
Upgradation, madam, I have told, please mention the urgency, hand over the slip. You need not mention.
lordship.
Lordship, to mention, it's also a similar matter appearing in monthly
Hand over
list.
the slip.
But Lordship, it's next week is the date in the trial
Maybe.
court.
Please mention that
I have
urgency, hand
mentioned
over
that.
the
If you
slip.
may, it is waiting for admission. If to next week hearing trial.
Hand over.
Lord,
Please, inclusion, I have said, motions, please hand over the slip. You need not mention, only for motions, not contested application. Don't hand over the slip for contested application.
Your Lordship, may I be permitted to mention, Manoj, in this matter, Manoj, my 7-1 application has been rejected.
What do you want, sir?
Manoj, application for Manoj hearing of 7 to Manoj fixed on Manoj 1st of
What
April.
do you want? Upgradation.
Manoj, this is not in the list. If this can be.
Then have you filed?
My lords, I have filed in February on the last occasion when.
February, what is the date of filing?
My lords, on 28th February, this matter appeared before.
28th
8th February, this matter.
28th February.
28th February, this matter appears before your lordship. My lord,
Yes.
the caveator has not been, my lord, served. That is why your lordship fixed this matter on, my lord.
You did not solve the caveator, what can be done?
The caveator has been served, my lord. First of
How
April,
you
7 to
have to
application.
wait for your chance,
My
yes.
lords, my lords, maybe, my lord, included, my lord.
1498, my lord. 15
What do you want? Please, please write it in the mentioning slip. Please hand over the slip.
Your lordship may be permitted. Your lordship,
My lord, mentioning for restoration.
When it was dismissed for default?
To 5/12/2024.
5/12 to 2024. Monthly list.
Your
Monthly list
lordship.
of May. Monthly list of May.
Your lordship may be permitted to mention one expeditious. Your lordship may be permitted to mention on expeditious hearing matter for inclusion. Your lordship, since 2009, the respondent authority have been taking adjournment.
When did you file the civil division application?
Your lordship, in the year 2023.
2023, I do not have determination.
My lord,
Yes.
my lord, may I permit to mention, my lord, may I permit to mention, my lord, your lordship, my lord, in earlier occasion, I have mentioned before your lordship, my lord, file has arrived, my lord. Despite of that, my lord, it has.
You have mentioned.
Yes, yes.
What
My,
is the endorsement in the mention slip? Have you checked up?
my lord, file arrived before this court, my lord. But despite of that, my lord, kindly, my lord.
Please verify. You need not mention again. If you have mentioned, please verify what is the endorsement in the
My lord, what
mention
happened, my lord? I am the preempter, my lord. I have got the ticket despite of that, my lord.
Please verify. If it has been rejected, you need not mention again. Yes.
My lord, I leave to mention, my lord, this is a matter, your lordship was taken up on 6th of this month, my lord, and I have been given liberty to file the supplementary affidavit annexing the necessary facts, my lord. And, my lord, the supplementary affidavit is made ready, my lord, and that has been served upon the caveator, my lord. This is the notice of service. And, my lord, if this matter, my lord, this is civil revision application is arising out of the rejection of an application under section 10 of the CPC, my lord.
When it was taken up?
My lord, it was taken up of 6th of this March, 6th March.
Yes. What is the direction?
My lord, direction to file the supplementary affidavit. My
It
lord,
will appear in due course.
my lord, kindly consider, my lord, the
Sir, you have got a chance.
fixed on 29th, my lord.
Maybe.
And the witness action will be initiated, my lord. Then
Nothing will happen. Nothing will happen.
my lord,
Yes.
this can be taken up.
May I have permission to mention, my lord, for two matters for early disposal, Your Honor.
Please don't mention
With your
for
lordship.
upgradation of our expeditious here.
Your lordship.
Yes.
My lord,
Yes, Mr. Chatterjee.
my lord.
Senior advocate is behind you.
My lord's kind leave to mention the matter I mentioned on the last occasion. Your lordship was not, did not, my lord, allow it on the last occasion, but there's
Why?
the extreme urgency. I don't know why, my lord. There's extreme urgency.
What is
my
the
lord.
urgency?
The arbitrator is not listening to us at all.
Arbitrator
Is not listening to us at all. At all. My lord, what happens is section 8, my lord, that has been, my lord, rejected, and that against that, my lord,
Section 8 rejected.
Section 8 is allowed. I'm sorry. It's allowed. Against that, we are here before your lordship. I'm saying, my lord, that there is no arbitration clause in the dispute that is there. Continuously going on, my lord, in Gurugram. Please appreciate, I am, my lord, almost a farmer, my lord, in Mednipur.
Mention the urgency in the.
I had on the last occasion for some.
Rejected, Mr. Chatterjee.
My lord, your lordship did not allow, hasn't rejected it, but your lordship did not allow it. But
Hand over the slip, mentioning the urgency in the slip.
My lord, may I be permitted for inclusion on contempt application? Your lordship.
My lord, contempt
With your
application.
My lord, my item number is running at 73 today, but at the same time, this matter will be taken before the Securities Appellate Tribunal at Mumbai. If you can kindly allow the matter to be taken at 2 p.m. today, my lord.
2
It's
PM
very
today
urgent.
not possible.
With your
Yes.
Please, I'm allowed to hand over the slip, my lord, writing the urgency.
Hand over the
lordship,
slip.
for release your lordship. For release your lordship.
Hand over the slip. Release.
May I permit to mention, my lord, for upgradation, my lord?
Upgradation. Please mention the urgency. Hand over the slip. I told you we did not mention individually. Please hand over the slips.
Lordship, may I permission to upgradation because
Upgradation.
for expeditious disposal of matter was filed 2024, my lord.
Maybe.
Next date given to
Yes. No upgradation for expeditious.
My lord, the urgency is that, my lord, my salary has.
Please
My lord,
mention
my
the
salary
urgency.
has
Hand over
been
the slip.
salary has been attached, my lord. I was only a witness in the agreement
Already.
by the.
Yes, Mr. Datta.
I mentioned this matter on the earlier occasion.
Item.
8 of month.
Yes.
This matter on the earlier occasion.
Yes, I asked you to come today.
Yes.
Hand over the slip mentioning the urgency.
I have given the urgency by mentioning the slip.
Please mention, give the, today you have given.
No, just last one.
Please hand over the slip today mentioning the urgency. Yes, call the list.
My lordship, lordship, my occupational costs have been increased from 800 to 8,000, and my
Only
lordship.
when I was there, occupation charges of 18,000 was made 1,80,000.
My lordship. My lordship, may I give the mention slip?
Yes.
Lordship, on the last occasion,
Please don't hand over the slip. It will be taken up in court. That is not an urgency.
but the difficulty
My
is that
lordship.
I'm a central government employee. My salary has been attached.
So you mention the urgency. Hand over the.
I was unsuccessful, and I
Then-
kindly appreciate, my lord.
Yes, yes, yes. Call the list.
One kind indulgence. It's for inclusion. Your lordship has admitted the revision 28th of Jan. It was said to appear last week of Feb, but it hasn't appeared last week of February, nor in the monthly list of March.
Direction.
My lordship, my matter was in
It's the ordered
February,
class.
my lordship.
Ordered.
It is in the list. I want upgradation, my lordship.
Upgradation.
Upgradation.
Mention the.
May I mention the matter?
Hand over the slips. Yes, call the list.
This is for,
My lord,
my lord, this is for.
Urgency. Please mention the urgency. Hand over the slip.
my lord, may I mentioning the matter? The matter was filing on 2024. It is the executions of interim order. Order has been passed on 1st May of.
What, madam? What do you want?
Applications are pending.
You want inclusion under the heading application?
Yes.
Please hand over the slip.
This is for upgradation, civil divisional application.
Please mention the urgency. Hand over the slip.
Item number 1.
Item number 1. It will be called on. Yes.
Only one thing, my lord. I have handed over the slip mentioning the urgency.
Then you
Only,
can mention
only
yes,
one
call the list.
indulgence, my lord.
Call the list.
And for the petitioner, my lord.
Yes. What do you want?
This is for withdrawal, my lord.
Non-prosecution.
Non-prosecution. Settle their dispute. This is my original letter and order of the.
The learned advocate appearing for the petitioner submits that the petitioners have instructed
I'm for the petitioner. Item number 2 to 7. All are analogous matters. The matters have become infructuous as the matters have been
has
resolved
been
in court
submitted by the
below.
learned advocate for the petitioner that
Brother.
correction to Liam to ঠিকই তো আছে লিয়ম ও ট্রাক হয়ে গেছে It has been pointed out that a typographical error has
My lord, in item number 9, I appear on behalf of the respondents, opposite party caveated, my lord. I'm led by Dr. Chapulesh Bandyopadhyay. He's leg before the Honorable Supreme Court, my lord. Yesterday also he had
told
mentioned.
yesterday. Yes, Mr.
My lord, a
Mukherjee.
day's accommodation.
I know your lordship has formed an opinion about this. But your lordship will kindly see, Lord, I've got only 2 points, Lord, to argue before your lordship. Lord, the suit, there was no prayer for Lord recovery of possession. The decree was, Lord, that the
You have to
plaintiff are
remove
in
the bamboo poles. You have to remove the bamboo
Lord,
poles.
I understand that, Lord. And
You remove the bamboo poles, Mr. Mukherjee. You need not possession. I've told you, Lanet Junior, you remove the bamboo poles. Nobody will go. Police will not go. Bailiff will also not go. Give a reasonable time within which you will remove the bamboo poles.
that is not what we ask the client. The client says, Lord, the time which I really cannot utter before your lordship.
Then, Mr.
You are
Mukherjee,
saying that about,
I will restrict that to the decree only. I will restrict that to the decree.
The decree, Lord, is Lord, erroneous in a sense that, Lord, the decree says,
Mr. Mukherjee,
Lord,
the
it is subject to appeal. We are in appeal.
There is no stay, Mr.
No, there
Mukherjee.
is no stay.
So let it be executed. If you succeed, then 144 is there.
Now, Lord, their execution was also for recovery of possession. Lord, that portion cannot be executed because we said.
I will only say restricted to the decree as passed.
Lord, why I say this? The decree is, Lord, that Lord, their right title was declared. It was also declared that the plaintiffs are in possession. When they filed the execution, Lord, apart from the mandatory injunction portion, Lord, asking my client to remove the bamboo poles, they also, Lord, sought for recovery of possession, Lord, because
that I will not allow. I have told you, Junior, not that, but only with regard to decree. Possession, Mr. Mukherjee, they cannot because they have not filed violation of that permanent or putting the decree of permanent injunction. Recovery cannot be.
Lordship.
Recovery cannot be, but only so far as it appears prima facie, it appears because they are also not here. He told yesterday when this matter, he told that today he will not be.
Because that is the incongruity in, Lord, the execution that we pointed out
to the decree. Please come to the decree.
Lordship. Your Lordship will come.
Page 20.
Lordship.
Only this part they will implement. So you
that
have
is-
to remove the bamboo poles.
Lordship.
I think, and other belongings. Remove their belongings, that is the bamboo poles from the suit property, from such and such, and permanently restrain that decree.
But permanently restrained.
Not recovery.
Not recovery.
Not recovery. Not recovery. So that is why if you have taken instructions.
The instruction, Lord, I wanted to cut short the matter. The time that they are asking for may not be, Lord, your Lordship will not be, Lord, with me. But Lord, the other thing was, Lord, that within what time they can remove, Lord, the time that they are saying is, Lord, December, which is not December.
Then I will restrict this, that it will be executed in the manner as in the decree, not recovery, not other things. The decree will be only executed.
But the decree, so far as it relates to the Lord, the permanent injunction portion.
Permanent injunction and the removal.
Are
mandatory.
directed to remove that.
To some extent mandatory so far as the removal.
That is.
And the permanent injunction.
Lordship. Lordship.
Yes. When he will be available?
Tomorrow, madam.
Tomorrow, Mr. Mukherjee, tomorrow.
Lordship.
Because he is in difficulty.
Lordship, Lord, I am not standing in the.
Lord, let the matter retain its position.
times to file an affidavit. Otherwise, you will be.
No,
in
no,
difficulty.
Lord, I will not
Otherwise,
take the
you will
burden
be in
on.
difficulty.
Yes.
You as counsels will be in difficulty.
Lord,
Please ensure that.
Lord,
If they are not agreeable, then if the court passes an order, it's
Lord.
well and fine. That is, need not file any undertaking. But if you find a reasonable time, then instruct they have to file because
But
you
I
have to be
understand.
protected. You as counsels have to be protected.
Grateful. Grateful.
Yes.
Sublime.
Ashun, Mr. Mukherjee,
Line 4 of the first paragraph at page 1, order number 157 should be order number 57.
157 should be 57 only. Ashun.
But in this matter, Mr. Bhaskar Prasad Bosu is appearing on behalf of the contemnor, my lord. Same personal difficulty, my lord, 2 days now, paying for 2 days, my lord, not to attend.
Court is waiting for him appear. Ashun.
My lord, may I placing my lord?
Chairman DPSC.
The same order which was produced earlier.
Thereafter, matter is pending, people the commission of school.
Lord, in this matter, my Lord, I am coming to your lordships against the order of the appellate court for police helper in this case. But my Lord, initially, my Lord, the case is the opposite party petitioner filed an application under section 8 of the West Bengal Land Reforms Act for preemption. And my Lord, both the court below are affirmed that application. And my Lord, thereafter, my Lord, the then learned advocate of the petitioner, my Lord, filed a revisional application before our High Court. And my unfortunately, my Lord, the then learned advocate didn't appear and matter of dismissed for default. Then, my Lord, the then advocate also filed an application for restoration along with section 5. Section 5, along with the application for restoration and section 5, my Lord, is pending before this honorable court. My Lord, now, my Lord, the client, my Lord, engaged me, and my Lord, I prefer my Lord, against the order of the miscase of the for police help. My Lord, my contention is, my Lord, the revisional application, earlier revisional application is very much point involved in that.
Maybe there is no stay. Please let the degree be executed. You succeed in the civil revision. There are provisions under the Civil Procedure Code for restitution. You will be entitled to restitution thereafter.
But only, my Lord, I pointed out, my Lord, the misappeal.
Where is the infirmity in the order? Please restrict your submission on the infirmity in the order.
Lord, infirmity in the order, my Lord, the process server did not specify the property, and my Lord, did not stay on the evidence, my Lord, who will oppose that.
Who resisted?
Who resisted? Yes, my Lord.
Mr. Bhomik, your clients are not resisting.
No,
I'll record that. And I will record your submission that your clients are not resisting. Then I think there will be no difficulty.
My Lord, only, my Lord.
Don't resist. Nobody will go there. You hand over the possession.
No, my
No
Lord.
difficulty.
My Lord, only.
I accept that you do not have any intention to resist. You did not resist.
Only my humble prayer before your lordships, not the application and earlier application under 227 is pending before
that may have been. There is no stay. A mere pendency of a civil revision application which was dismissed for default. Restoration application pending. No stay is there. Let the degree be executed. If you succeed, there are provisions in the Code of Civil Procedure for restitution. It will be again restituted. But please comply with the decree for the present.
My Lord, only, my Lord.
And I shall record that your clients are not resisting.
Not only, my Lord, the order.
Are you making that submission that your client did not resist? I will record that.
Lord, that is the.
This shows that your clients have resisted, Mr. Bhomik.
Before
so
that,
you are not agreeable to that recording. So this shows your client resisted.
My Lord, only, my Lord, point out lordships. Lordship, kindly see page 31 of the certified copy of the order, my Lord.
Page 31, yes.
Lord, mistake, my Lord, I pointed out your lordships, the mistake, my Lord. My Lord, the appellant opposite party, Nipun Kumar Bosak. Versus not Manjurani Bosak. My Lord, the title is wrong. It's Manjurani Shah.
Manjurani Shah.
There is no difficulty, my Lord.
They are the respondents. It is you who have mentioned wrong name in the cost title. They are not challenging.
I mentioned the correct cost title, my Lord.
No, miscellaneous appeal.
No, Lord, should kindly see the miscellaneous appeal.
Mr. Bhomik, they are not affected. They are not coming. There is a mistake in their name. Even then they contested.
I entirely your lordships. Only, my Lord, lordship, kindly record, my Lord, the application under 227 of the is dismissed, my Lord, and the restoration application is
filed. I will record that.
for my satisfaction. Your lordships kindly take it that if I succeed in the divisional application.
That is provision is there. Provision is there, you have to apply. Yes, call the next matter.
My lord, in this matter, my lord, Mr. D.N. Sharma appears for the petitioner, my lord. He is not well, my lord. He has not come to court, my lord. I am only praying for 1 week time, my lord. Kindly adjourn for a week, my lord. I have served the
my lord,
affidavit of service is there, my lord.
my lord, I am appearing for the opposite party. I am leaded by Saptangshu Basu, senior advocate.
Yes, yes. Please move.
My lord, he is not well, my lord. Kindly adjourn for a week, my lord. He has personally requested me, my lord. If your lordship
Then
may
don't
kindly grant-
mention for upgradation.
But only
Today you have a chance. If you want to move, you can move. Otherwise, I do not know when it will be taken up.
Doctor, let me try my luck next week, my lord. Let me try my luck next week because Mr. Sharma, senior advocate, is there, my lord.
Maybe. Today is the time you can avail of the opportunity. After today, nobody knows what will happen. But don't mention for upgradation.
My lord. I will take my chance, my lord, next week.
Next
I will not
week,
mention.
which
I will
week,
not.
I do not
I
know.
will not mention for upgradation.
An accommodation.
Yes, my lord.
Yes,
My
call the
lord has
next
not
matter.
declared that the matter will appear next week, my lord.
What's the next matter? আপনি দাঁড়িয়ে আছেন কেন?
Now, may I file my affidavit of service?
Immediate service taken on record. Yes, next.
Now, no date has been given when the matter will appear, my lord. Kindly,
I've told you.
my lord, kindly give at least.
Sir,
My lord, matter will not be there.
even there are many who is not getting one chance. You have got one chance. You did not avail of that chance. There are many matters in the monthly list who have not got one chance. And you have got one chance. You did not avail of that. Yes, next matter, please. Yes.
My lord, in this matter, I am on behalf of the petitioner.
Yes.
The petitioner, my lord, is an old lady filed an application under 372 of the Succession Indian Succession Act 2019-25, praying for a succession certificate in towards the valuable assets those are lying in the Central Bank of India.
What can be done? You have withdrawn that application.
No, my lord. I'm coming to that. Though subsequently, the opposite party also filed their objection and said that he has no objection in granting the succession certificate in respect.
Where is that?
That is in, my lord, you will find at page number 20 of the petition.
20.
20. He filed an objection and said that he has no objection towards granting the succession certificate in favor of the petitioner. Page number 3 and 4, my lord, you will find that. Page 21.
This was in 2023.
Yes, my lord.
So after that, you have withdrawn this.
No, my lord, the thing is, my lord, I'm coming
When
to
did
that.
you withdraw?
My lord,
I
I
withdrawn in 2024. So after that, you have withdrawn.
No, subsequently, what has happened, my lord? On if my lord kindly comes to the withdrawal application once, 23.
Yes, page
23, paragraph number 3. During the pendency of the suit, due to intervention of the well-wishers and friends of both the parties, the dispute between the petitioner and OP resolved amicably. My lord, succession certificate, succession case, I don't know how can be settled amicably. Somehow the withdrawal application was allowed, my lord.
But you have
withdrawal, my lord, without
liberty.
I can understand. I'm coming to that. Subsequently, my lord, what happened when petitioner withdrew it? Petitioner was instigated and somehow was told by his well-wishers, whoever it may be, that in the event the petitioner withdraws the case, the petitioner will be helped in getting the liquids or whatever is liquid asset, whatever is lying in the central bank, to get it liquidated through the help of the branch manager, and he hasn't had to continue with the case. Subsequently, I'm relying on several judgments on this aspect. So
Expeditious disposal.
Of what?
Petitioner filed partition suit.
What is the stage of the suit?
That has not been admitted also there.
This application under Article
Yeah. My lord, I am appearing on behalf of the petitioner. I am
Yes.
paying for expeditious of trial. My lord,
of what?
Of the injunction application under order 39 rule 1 and 2, as well as the civil suit. My lord, the suit was filed in the year 2015. Thereafter, only one order.
Till now you are fighting with the injunction. So how can the civil suit be disposed of?
My lord, let them let the direction may be given to dispose of.
You have filed you are the plaintiff.
No, my lord.
You are the defendant. You have filed your written objection to the injunction application. This application under Article 227 of
Lordship, in this matter, Lordship, I am appealing on both petition, Lordship. Lordship, yesterday night I have lost my paternal aunt, Lordship, and whole day, Lordship, I returned from funeral expenses from Barningham, Nimtala Barningham, at about 9 a.m. this morning. Lordship, that's why Lordship, I'm not in a position to submit before Lordship. At least 2 or 3 days, Lordship, time granted, Lordship, I'll complete submission and complete hearing on Monday, Lordship. Kindly, at this circumstance, kindly adjourn the matter.
You have filed this application.
Yes, Lord, this is my application, revision application, Lordship.
But the advocate on record.
Yes, Lordship.
You have drafted the petition.
Yes, Lordship, drafted the petition, but some, Lordship, I compliment some judgment and some preparation. That's
What
Lordship.
judgment? After Barasat Eye Hospital, Abdul Motil Mullik,
Yes.
what judgment you will cite? Do you have any judgment after that?
So at least let's see.
Do you have any judgment after that? So you must have considered that while drafting this application.
Yes, Lordship.
I'm not against granting you time, but there is nothing. After Barasat Eye Hospital, short consideration gone.
Yes, Lordship, but I could not submit because I am in trauma because I lost my.
I appreciate that, but considering this point, Barasat Eye Hospital, you are also aware of that because you have drafted. That is why I asked you. You have drafted this petition.
So
have you got hold of any decision after Barasat Eye Hospital and Abdul Motin Mullik? Issue is well settled now. The earlier view of the Calcutta High Court gone.
Kindly, at least for that much level, just
The issue involved in this application is whether Monday. Yes, next.
18, my lord, I am for the petitioner, my lord. It's my application for expeditious disposal of the misappeal, my lord. It was filed sometime in 2014, my lord, by the defendant number 1, my lord. I am for the defendant.
Serious appeal is against injunction.
No, my lord, against Order 9, Rule 13, my lord.
Against Order 9, Rule 13.
Yes, my lord. It was filed with the defendant number 1, my lord, and I am the defendant number 2 in the suit, my lord. The suit was decreed on 2000, my lord. Sometime in 2000. But they are on records, but the legal heirs are on record, my lord, and the death certificate has already been submitted, but it is continuously been recorded that death has not been submitted. And it is continuing, my lord. Yesterday was the last date, my lord. Then also it was adjourned.
This application under Article 2.
I am for the plaintiff landlord, my lord. Suit for recovery of possessions under 1956 Act. Lordships kindly to come to
1956 Act.
56 Act.
What happened?
Now, your lordships kindly to come to page 47. My
Yes.
17.2 application was allowed, but while the learned judge computing the interest, he has applied the 1997 Act. Interest part, calculation. Now I have filed an application.
You are getting less amount. What is the ground in the suit? Why are you fighting with this?
No,
Are you interested only on the money?
No.
What is the ground in the suit?
Suit for recovery of possessions, default, all.
Reasonable requirement is there.
Yes.
So you don't have a good case on reasonable requirement?
Yes.
So why are you fighting out on
Now,
this?
what it happens, my lord, kindly to see thereafter for correction of such mistakes, I have filed one application. Now the learned court allowed my applications and computed the interest under 1956 Act.
So now
by order dated 11th July 2024, page 55.
Yes. Now what is the difficulty?
Now what it happens, challenging this order, page 55, 11th July 2024.
They have come up.
They have filed a CU application is pending. Now the learned judge, what is happens in view of pendency that you will not have to deposit.
Yes, has to be. Because unless this is decided, it cannot be. You have created this trouble. That is why I asked you, why are you on the interest part? You have created this trouble. Without that, it cannot be decided.
Now I will say, I will sub copy of this application and the item number 617 of monthly list. Let both this
That is not your application.
No, their applications. They have sub me a copy. I will have to sub copy upon them and both this matter.
Have created this problem. When you told me you have created this problem, you are fighting with the interest. What you will do with the interest?
Your losses have an interest. Vast experience, your losses.
I do not have any experience.
No, your losses are
You submit
My junior is trying to do this case. My junior is.
Yes.
Madam, this is an
Mr. Mukherjee
application.
is opposing.
No.
Madam, this is an application for expeditious disposal of order 39 rule 4 in Madam annex page 36.
Expeditious hearing of order 39 rule 4.
Lordship. Madam,
Who are you in the suit?
Madam, I'm the defendant number 2 and 3 in the suit. Ex parte order in declaratory suit was obtained by the plaintiff therein, and my next date of hearing is fixed on.
What was the identity order? Status quo order was passed.
Yes, Lordship, on 27th June.
What is the next date fixed?
My Lord, next date is on 30th April 2025.
30th April.
My Lord. My Lord, mentioned in para 8 of page 8.
Injunction was sought for against. Where is the injunction application?
Madam, the first page of interim status quo, Madam, page.
No. Where is the application for injunction? Injunction paid against whom? Which defendant? Against both the defendants.
2 and 3.
How many defendants? 3 defendants.
Defendants, Lordship.
So defendant number 1 has not yet been served. Service returns.
Madam, he has not preferred any application over this court.
Order 39 rule 4. Only you want. Assume.
I am for the plaintiff petitioner in a suit for eviction. Number before filing of my suit, 6 months ago, my lord, the defendant filed a suit for declaration and injunction.
Your suit has to be stayed. Subsequent suit.
Now what happened, my lord?
It has been done.
Now
by the impugner, rightly done, Mr. Mukherjee.
Now both the suits are pending same court. Now our issues with
stage is same.
In my suit, my lord, they have just filed a written statement. When my lord ultimately cost has been imposed, they have filed a written statement.
You are opposing the prayer for acceptance. You are opposing the prayer for acceptance.
Yes.
So let your suit be stayed. You contest that.
Both the suit has to be heard in. Both are pending in same court.
So you will not oppose the prayer for acceptance of the written statement.
Already accepted.
Accepted. You will not challenge that. Why?
Because I want my early disposal because I am living.
What is the stage of this is in your suit?
My suit for eviction.
In your suit, Their written statement has been accepted. Belated written
Yeah,
statement has
now
been
issue has
accepted.
been, issue has
And
been
in
framed.
their suit, what is the stage?
In their suit, my lord, next date has been fixed for filing of affidavit in chief. And in my suit,
So more or less at the same stage.
issue and chief. Kindly grant stay of both the suits, and if you like to kindly fix motion so that my lord, ultimately, because my suit for eviction, my lord, I am residing in a tenanted house. That is merits, my lord. Or পড়ে আসলে হবে? The lordship has already.
It's better to reside in a tenanted house. So your only obligation is to pay rent, nothing more than that. By the order impugned, Yes.
In this matter, I am for the petitioner, my lord. Petitioner filed a title suit declaration and injunction against his son. In the meantime, my lord, defendant number 2 filed an application order
Filing against son, why?
revocation of deed. Revocation of deed, my lord. Give
Who are you? You are the father of the son.
father.
You have gifted your property to the son. Why?
Yes, my lord. In the meantime, the defendant number 2, he filed an application order on rule 10(2) substantially add to party in this suit. He has no right, my lord.
Who is he?
Who is money? He is other. He is money. There is no relation between the son, father and son. He want to.
This is from Baripur court. Can I take up this
Yes.
matter?
Baripur, man.
Can I take up this matter? Have you ascertained?
Baripur.
Can I take up this matter? Do I have any difficulty in taking up this matter?
No, no, no.
You have ascertained?
Yes.
Or without ascertaining, you are saying no, no. Please ascertain. On the, please ascertain on the prayer of the learned Yes.
See, hey, please, your lordship. My lord, I appear on behalf of the defendant petitioner in this matter. My lord, that praying for expeditious disposal of a suit ES 36 of 2023, pending before my lord, the learned court 6th bench at Howrah. My lord, the suit that has been filed by the opposite party, they are the tenants of my property, seeking declaration of the status as a tenant in the property. My lord. Now, my lord, accordingly, they have, if I may indicate,
Has the presiding officer joined?
no, my lord. Still vacant, my lord. Even the charge court is not willing to take the matter.
Then
This is
can the charge court hear out a suit?
not the suit, your lordship. My lord, what has happened during the pendency, my lord, they have obtained the ad interim order. Thereafter, my lord, we have filed an application under Section 8. My lord, just after 2 months, my lord, on July 2000.
Arbitration and Conciliation Act.
Yes, your lord. Section 8, my lord. Now, my lord, what the in view of the mandatory nature of Section 8, my lord, this has to be heard first, whether the suit will be there or whether it has to be referred to the arbitration. Now, my lord, before the submission of my first statement, your lordship, I have made this application. Now, your lordship, written objection has been filed by the defendant as well. Now, my lord, we await the hearing of this application, your lordship.
Difficult. By the charge court, it's difficult.
My lord, kindly makes a direction on the charge court as well, your lordship. This is the difficulty, your lordship. My lord, kindly appreciates, your lordship.
Charge court, it's difficult.
For the petitioner. Application number 24 of the
Transfer.
transfer
From where?
from the
Paschim Medinipur to?
contact to Kharagpur. Because of the fact,
What is the
Lordship, kindly see. But 498A and 125 already filed. Marriage solemnized 2018.
But
I
the
am a
distance
court.
is
No, no,
not
Lordship,
much.
kindly consider paragraph 9 and 10. But I am the maid servant of our family. And I, my lord, they got place, Lord, I have taken shelter of them. And Lord, my child, 4 years child, Lord, with me. Lordship, kindly consider that. That's why, Lord, I know your Lordship. Lordship, kindly consider 490 to 125. He has attended. Thereafter, Section 9. Section 9, thereafter.
Go back to your husband, Mr. Banerjee.
How? Lord, torture, Lordship. Lord, I can produce to your lordship the photographs also. But I am a poor lady.
This application is, this application under section 24 of
I am for the petitioner. My lord, I am here, my lord, for refusal of granting ad interim order in a meritorious petition, my lord. My lord, the defendant
No, I
has
could not
forged
follow.
two deed of lordship.
I could not follow.
My lord,
Yeah,
for refusal of ad interim order by the learned court below. My lord, the case, there is a prima facie case in this petition, my lord. But the ad interim order has been rejected at the initial stage and the suit is being proceeded by the learned court below, my lord.
no,
My
after
lord,
the refusal of ad interim, you have filed a miscellaneous appeal.
Lordship, I am challenging the order of the appeal court, my lord.
Yes.
Because, my lord, the defendant has forged two deed of gift, my lord. And from the face of the
The
record,
order
it will
is
be
under
apparent.
challenge.
My lord,
The order we achieve of
320, appeal 320, my lord. Certified copy, my lord.
Yes.
322, my lord. My lord, the first order was 14th September
Are
2020.
you challenging that order?
Yes, my lord, and thereafter, my lord.
So that was in 2023.
My lord, I am coming, my lord. That was in 2023, my lord. Thereafter, my lord, several dates were given, but without ad interim order.
Directed the miscellaneous appeal to be disposed of.
My lord, with the further direction of status quo as on today, my lord.
No.
Because my lord, kindly listen.
That order was on 14th of September 2023. Today we are on 2025. No ad interim order now.
My lord, hear me for 2 minutes, my lord. My lord, the months, my lord.
Sir, service is not yet complete. Even then, I have passed this direction.
Lord, sir.
Without service, miscellaneous appeal cannot be directed to be disposed of.
Lord, sir.
It's SR and AD against respondent number 4. And
Proper steps has not been taken by the learned advocate.
you have to take steps. It's not for the court. You have not put in the requisites. Yes, next.
Lord, sir.
Lord, I am for the petitioner. Lord, I am for the opposite party, caveator.
Yes.
Lord, the defendant is the petitioner before your lordship in a suit for specific performance of contract. Lord, in the suit, my lord, after entering appearance, I filed my written statement, specifically stated that the plaintiff was a tenant under me, not under me, but under my husband. My husband transferred the property in my favor. There was no agreement executed on my behalf wherein my husband has signed as a witness. I disputed my signature as well as the signature of my husband in the written statement. In such conspectus, initially I filed an application under Order 26 Rule 10A for appointment of handwriting expert for comparison of my signature, appearing in the disputed agreement for sale, not with a specimen signature of mine.
Disputed agreement for sale has been marked as an exhibit.
I'm coming. That's right. But initially, that was turned down. I came up before this honorable court. This was turned down on a separate premise. I shall show before your lordship that order. That order said that since the plaintiff has to prove his own case, so it is not my burden to prove my signature. On that score, it was turned down. I came up before this honorable court. This honorable court set aside this order, saying that no, it's a wrong premise. Reheard the matter, though impugned order was being set aside. After remand, again, my application was dismissed on the ground that yes, now this is a premature stage, the document has not come up in evidence. Liberty was granted at the time of refusal after remand that yes, you can file an application after the document come up in evidence. When the document come up in evidence, they have tendered, immediately I took out my second application. That application of mine was turned down, saying that no, since you being the author of the document, alleged author of the document, you have an opportunity at the time of cross-examination, you can dispute your signature at the time of confrontation, though I have disputed in my written statement. So this is also not the stage. Liberty was further granted that at the time when the document is being confronted to you at the time of cross-examination, if you deny the signature, that will be the cause of action. You can file the application. The document comes up in tendering, not in tendering, in confrontation in DW1 cross-examination. I dispute that. Thereafter, I took out my third application. That has been considered by the order impugned. The learned judge, without looking into all those previous affairs, said that it's barred by res judicata. Because my application times and again is being considered and rejected by the learned court, and I am filing the application one after another. That is totally wrong premise. Now, may I hurriedly...
Where are the earlier orders?
Yes, Lord. May I hurriedly, take your lordship?
Show me the last order.
Very well, Lord. Last order.
Giving you liberty.
Yes.
The liberty যেখানে দিয়েছে না
But if your lordship takes up page 41 of my lord's brief.
No, this is the trial judge's order. After that, you have not filed a civil division.
This
page 41 is the
41 is the last rejection of mine.
No, this was not challenged.
This was challenged. But civil division is pending. There is no But I take it, this order, to be an order passed which I have accepted. Which I have accepted.
You will not press for your civil division application, Mr. Mukherjee.
Kindly takes up the order. Kindly take.
No, I am asking you. I will record that first.
Very well, your lordship, record.
I will not press. Ashun. In course of hearing of this
No, my lord, very. Kindly takes up, my lord, the page 41 order once.
Yes.
My lord, may I please consider the submission of the learned advocate, not that paragraph, third paragraph of the plaintiff and the defendant peruse the material. It transpired that the maker of the alleged document Bainanama is the defendant. When the maker of the disputed document is available as witness, then there is no question of sending the document for seeking the opinion of expert before examination of the maker. Ordered that the petition dated such and such praying for seeking opinion of the handwriting expert in respect of the document Bainama marked as Exhibit 2 is rejected on contest. Liberty is given to concerned defendant to file the same afresh if necessary after evidence adduced by the defendant. So if I take this order, my lord, to be true and correct, then my lord,
Show me your evidence.
yes, my lord, kind. Not signature. Out of the
Which portion?
Yes, my lord, the signature 4/7, my lord.
4/7.
4/7 is the, my lord, signature, is the disputed signature. My lord, I shall show before your lordship.
No, 4/7 is the signature in the Vakalatnama.
No, I shall show before your lordship.
This is your evidence, Mr. Mukherjee. What are you saying? No. The marked portion. Do you have another copy?
May I just
The marked portion. Double line, then tick.
I have
specially marked. Eta din to.
Shop chhoriye tha. But I have a copy of exhibit list. May I just find out?
No, but this is your evidence. Upon looking at the Vakalatnama, you said this is my signature, which was marked as exhibit 4/7.
Signature
double line, Mr. Mukherjee, double line, tick.
Signature appearing in the Vakalatnama of the defendant is shown to DW1.
Yes.
This is my signature. This is the Vakalatnama of mine appended to the full statement. Yes, I'm coming. Exhibit 4/7 is shown to defendant number 1. This 4/7 is, my lord, the disputed signature appearing in the Bainanama. I am showing, my lord, from the exhibit list.
Don't scold your junior, Mr. Mukherjee. This was
not 4/7, my dears.
You have not filed your written statement, Mr. Mukherjee?
Yes.
There also you are denying your signature in the written statement.
Page number. I shall place that.
Signature appearing in the written statement is not my signature.
That is, my lord, something which is went wrong, my lord. কালকেই তো দেখলাম রে বাবা। Kindly see, my lord, this is the exhibit list. Exhibit 2 is the Bainanama. Exhibit 3 is the signature of my husband in the deed, and Exhibit 4 series as the signature of the Shondharani, that is your, my lord, the petitioner before your lordship in Exhibit 2.
Exhibit 2 is the agreement.
Exhibit 2 is the agreement, my lord, recorded in the order impugn. My lord, I have marked in pencil. Kindly, my lord, excuse me for that.
Yes.
So, now, my lord, if your lordship takes up, my lord, I shall show before your lordship what is my application, third application. My lord, immediately next page, my lord, if your lordship takes up page 42, side by side, your lordship keeps, my lord, my cross-examination. My lord, I shall show, my lord, what I have prayed in the third application. My lord, I have narrated.
Give me a minute.
My lord.
Where is the earlier order passed in the civil division?
Milord, yes. Your lordship takes up. Milord, the first rejection of the trial court is at page 30. First rejection, Milord.
Yes.
Just your lordship looks at page 32, last few lines. In this case, the plaintiff come to this court. Yes, to this court alleging that the first defendant had executed an agreement for sale in his favor. The
So
first
page
defendant,
32.
page 32, Milord, I am showing just the operating portion of first rejection order.
Yes.
Milord, 5 lines from the top, it starts with in this case. Yes. In this case, the plaintiff came to the court alleging that the first defendant has executed an agreement for sale in favor. The first defendant having denied it, the burden was on the plaintiff to prove that the first defendant had executed the agreement and not upon the first defendant to prove the negative. So this was the premise. Kindly takes up now page 33. This has been assailed before this honorable court. Not the coordinate bench ultimately directed the matter to be reheard, not upon setting aside.
After that, what happened?
After that, my lord, kindly takes up page 35. The second rejection. Kindly takes up page 36. My lord, your lordship need not venture, my lord. My lord, the premise
of the Bananama being tendered in evidence.
Yes. So, my lord, there also a liberty is granted. Kindly takes up the operating portion.
That order has not been challenged.
Is tendered in evidence.
Yes, I have accepted this order. Kindly takes up now my second application, page 37. Kindly
So that was rejected in page 41.
Kindly takes up page 37 and 38 once. Page 38, my second application premise was that Badi Ukto Bainanama Adalate tender evidence koriachen. So that point is being taken into consideration. That was rejected by page 41. Your lordship is absolutely correct.
So this was tendered by the plaintiff.
This was tendered by the plaintiff. Marked as exhibit 2. Signature 4/7. 4 series, my lord.
After the evidence is adduced by the defendant.
Now, my lord, may I take their case to be, my lord, what is best case of there? My lord, kindly takes up your lordship has seen, my lord, my application, third application, starts with page, my lord, 42 of my lord's brief.
Yes.
My lord, the page 6, my lord, paragraph 6 is, my lord, the premise on which, my lord, this has been done. But in this, my lord, third application, my schedule is not remains the same. What difference, my lord, I shall show before your lordship. Kindly takes up, in the earlier 2 application, I only prayed for comparison of my signature. But in the present, my lord, impugned application before your lordship, kindly takes up the schedule, page 45 and 46.
Signature of your husband
as well. So this is an additional texture, my lord, put to my earlier application in the third application of mine. What is, my lord, their written objection?
So husband's signature you have disputed.
I have disputed, my lord, I have
in your evidence.
As well as in the written statement.
In the evidence,
in the written statement, I have disputed.
In the evidence?
Yes, my lord. Subject to correction, my lord, I have seen, my lord, last night, my lord.
You have denied that your husband was the witness.
Yes. And in the written statement, my lord, specifically, I have not shown before your lordship, paragraph 15 of my written statement specifically dealt with. Categorical denial, it is forged, manufactured, not my signature, not my husband's signature. Kindly takes up now their best case in the written objection. Page 48, last written objection of there.
This is the best case, Mr. Mukherjee.
What can be their best case? Because your lordship has already noticed that I have disputed my signature appearing in the written statement. But they themselves has tendered, my lord, that have confronted my signature appearing in the Vakalatnama. I said, yes, it is my signature. Lord, your lordship, kindly take it in your lordship's mind. Kindly takes up now what is there, my lord, defense case. My lord, kindly takes up paragraph 7, 8 and 9.
I'm at 8. I'm at paragraph 8.
Paragraph 8, my lord, they have stated that since I have disputed my signature in the written statement, so what can be done? Specimen signature. They have stated I can be now try to change my signature in a different way. So, my lord, the signature of mine taken by the court specimen signature at this point of time may, my lord, deviate the issue. So, if their case to be taken as a sacrosanct, then, my lord, my vakalatnama, which was filed way back in 2013, and this disputed, my lord, signature in the Bayananama is executed in the year 2012. So, even I take that case to be sacrosanct, then, my lord, that signature of mine can be compared with the disputed
What is your admitted signature with which you want to prove this?
My lord, the vakalatnama.
Where
They
I
have not
stated that in the points.
My lord, that I want because, my lord, my application.
Show me from your points.
My application, my lord, may I tell your lordship, my application was on the premise, may I show before your lordship the schedule, that court may take my specimen signature and compare it with the, my lord, the disputed signature appearing in the, my lord, Bayananama. They stated I can.
Bayananama was of the year
2012. My signature is of 2013.
Which signature is
Vakalatnama. Filed at the time of, my lord, filing of my written statement.
No, this is a suit of 2014.
No, my lord, 2012. Yes, renumbered. 2012. My lord, your lordship will get, my lord.
But you have not said with regard to the, your prayer is not with regard to the Vakalatnama.
Not. Because, my lord, if
present signature will be.
Present signature will be, yes. My lord, your lordship is absolutely right. It changes by passage of time. But as per, my lord, their case, they confronted, my lord, rather, my lord, I will be very helpful.
Yes.
My lord, they already taken the, I have already stated in my 49 page number, my lord, paragraph number 8, they denied the signature in the written statement.
How do you support this finding that it's barred by res judicata? On that ground, it was rejected, not on merits.
My lord, they made an application on several times, and several times they have came before the honor.
Liberty was granted to make a fresh application, not challenged by you. You have accepted that.
Yes, my lord, liberty is granted, but the my lord, their intention to drag this suit, my lord, in the civil court, my lord. They have taken all of time, my lord, since 2012.
This ground cannot be supported. This application under Article 227 of the Constitution of India.
This officer will require that one page order I have handed over before your lordship. That's CO number.
Yes, CO number, give the CO number. Yes, call the next matter.
27, my lord, I am appealing for the petition. The plaintiff is the petitioner before your lordship. Suit for eviction is such a suit, my lord. Eviction of a licensee.
Plaintiff is the petitioner.
Plaintiff is the petitioner.
Suit for eviction of a licensee.
Yes.
What
Well,
happened?
according to us, the rent is rupees 25,000. So it comes outside the purview
Rent,
of.
you are saying licensee, you are saying rent.
We are saying licensee. According to the license fee was rupees 25,000.
That's true.
License fee. Now we filed a suit for eviction under the Transfer Property Act. They filed a suit for declaration of tenancy right. I'm drawing lordship attention only two.
What has been done? What is the implicit order?
Order 12, Rule 6 rejected.
Order 12?
Rule 6. Judgment on entry.
So, what is the admission?
Yes, that is that. Only can you turn to their suit? It starts from page 42.
Their suit. You are saying you are the plaintiff.
I am the suit for the file.
So their suit for declaration of tenancy.
Right. Page 42.
Mr. Rai, you are not admitting him to a tenant. So,
from their own documents, I will satisfy. Order to Rule 6.
Your case is that they are licensee. Their case is that they are premises tenant or a tenant, monthly tenant. So they are not admitting that licensee. Where the question of admission comes.
Page 49.
49.
The suit filed order 6. Page 49, my lord. And it's F.
2 volumes of
civil
division application.
Volume 1, my lord.
Mr. Rai is appearing for the petitioner in this has to be considered. How
That
can a
is what-
decree for eviction be
that is
passed
fifty.
in this? They have
That is
challenged
50.
this.
On what aspect? My lord, Kali,
Maybe on what aspect?
I have to
Mr.
show that the notice I've received. I've served the notice,
Maybe-
validity of the notice.
Maybe they are challenging the validity. Validity has to be gone into Mr. Rai.
Validity, I put this question to myself. What is the validity of notice in respect of eviction? Even if my lord Kali consider, what is the premises for rejecting? What is the premises?
Mr. Rai,
It is also property act suit. Rent encompasses all the amenities. Even electricity charges is a constant factor according to the.
what is the stage of the suit? Of this suit for
My lord,
eviction? What is the stage? What is the stage? I'm asking.
Its trial will start.
I'm expediting the suit.
Oh, my lord Kali consider, if this is merely saying my lord Kali consider is a fact,
You will get a decree there prior to this being heard out. I'm telling you.
I'll try my luck over here. I'll try my luck over here. My lord, this is we are covered. My lord Kali consider is a suit under the Transfer Property Act. It is admitted. According to them, 90,000 is the amount which they paid monthly to the plaintiff. If the 90,000 is more than 10,000, it cannot come within the purview of Westbound Premises Tenancy Act. Now, my lord, the remaining factor is the notice. He admitted.
They have not admitted 19,000 because 10,000 they have said electricity
Yes.
charges. But they have not said it's part of rent. They have not said it's part of rent.
Fixed component.
Show me
Yes.
that paragraph once. It's not. They have said rent along with such and such. Show me that page once.
Yes. Page 49. It is pertinent to mention here.
No. Mr. Rai, kindly go through this page 49. Apart from the monthly rent of 4,000. So 4,000 is the rent. The plaintiff is also paying maintenance charges 5,000 and electricity. So these are exclusive of the rent.
Subject to question, my lord, that came up for consideration before this honorable division.
That has to be, Mr. Rai, it's not admission. They are not admitting. You may construe that this will be a part of rent. This has to be decided. They are not admitted. According to them, rental part is only 4,000, not more than that.
Was there for a moment, my lord, according to that, come to later bit. Question does not accept.
Admissions are to be clear, unambiguous.
So whether my lord,
No.
maintenance charges included in the combo. I am not saying that.
Make those arguments that it will not
My
fall.
lord, maintenance charges are also included in the rent.
Not electricity.
Subject to question, my lord, the electricity charges are also there.
Those are interpretations. It's not admission, Mr. Rai.
So according to that, these are fixed charges. Man can consider that every month 10,000 rupees electricity
I
charges.
appreciate, but they say rent is 4,000.
Yes, barely. So in any event, man can consider what are the rules 6 if your lordship can consider.
Moreover, they have challenged the notice, they may fail.
Notice what?
They may fail on the validity of the
Man can consider what is the notice for? They have admitted that yes, notice. They have issued the notice by requesting me to deliver position. So what more I have to give a notice under section 106? What will be more than that for the purpose of admission? It is not a case that the suit was filed.
Where the property is situated.
Howrah, a big go down.
Panchayat.
GT road, over the GT road. There are
Commercial.
Commercial. I have to prove that the notice was issued.
Get a decree, thereafter you will get occupation charges at this rate.
Already
Their admission.
Already, my lord, we have asked for occupation charges. That was also rejected. We as it were.
During the suit, pendency of the suit.
That is also there. But I want to satisfy your lordship. What more I have to prove?
Judgment on admission not clear, unambiguous.
This came up for consideration before this order got on division bench. Yeah, Mr. Judgment. Yes.
I'm aware of those judgments, Mr. Rai, but those cannot be admission.
But admission, the Honorable Apex Court has said, admission must be unequivocal. This unequivocal word does not mean merely saying that rent such and such, maintenance such and such, and does.
It says, qualifies by saying, Mr. Rai, if you have said, I'm paying such and such as rent is one thing.
That is why.
Apart from the sentence, apart from the monthly rental of 4,000. So according to them, monthly rental is 4,000 and paying maintenance charges. Show me your pleading with regard to the license fee.
Yes. Page 33.
Yes. What is your case made out?
As
the license
fee? 32.
Yes.
That although the license has been created, no formal document license in respect of ever generated by the plaintiff in favor of the defendant. It is important to mention here that the inducting defendant licensee, the plaintiff previously inducted one Manoj Kejriwal as licensee as licensee rupees 50,000.
Your case is 15,000. They are saying 19,000. It also not matching.
Subsequently,
So it is a disputed question of fact. What is the license fee?
so then also that portion can be considered for the purpose of whether eviction decree can be stalled. Man, can you consider order to rule 6 once? To what extent or judgment on admission can be passed?
Sir, there is no question of staying.
It is my suit. I will suffer.
Nothing.
No, my lord.
Proceed, you will get a decree.
No, my lord. I will suffer. I am willing to suffer.
No.
I am willing to suffer. The plaintiff is inviting.
Adjournment there. It's your suit. It's your right to take an adjournment.
My lord, merely
By the order impugned. Yes, the the date has been fixed for hearing of the temporary injunction.
Your Lordship, our
Happened on 28th of February.
Lordship,
What are you challenging? This order of injunction you are challenging.
the order of injunction, Your Lordship. Our innocuous play was that on 28th we filed an application for Order 7, Rule 11.
28th of February 2025.
Yes, Your Lordship.
Yes.
On that day, we made a prayer that while the status quo order was being granted, the application under Order 7, Rule 11, we heard on the next date. Now, while passing the status quo order, the learned judge has fixed the matter for hearing of the injunction application and kept that application under Order 7, Rule 11 in abeyance. That was our only
grievance.
That was our only innocuous prayer.
Objection with regard to the maintainability of the suit is
That
taken,
needs to be
has
said.
to be
Yes.
decided.
I know what is this here. In a partition suit, admitting I am the co-owner, he filed order 711.
Mr. Basu, in each and every case, there is Order 7 Rule 11 is there. Each and every case.
For the bar.
It's very difficult to find out a suit where there is no Order 7 Rule 11. That is happening.
Let it be heard out, let us file objection. But this is the application. 711 application admitted my joint ownership. And thereafter say suit is not maintained.
Take this point, argue that. What is the date fixed for Order 7 Rule 11?
Lordship, no date has been fixed. The next date of the suit has been fixed on 28th of March.
28th of March. 28th of March, it has been fixed for extension of the interim order.
No, for hearing of the injunction application.
Hearing of the injunction application, prior to that, Order 7 Rule 11 to be taken up.
Obliged.
Prior to extension.
Probably not possible.
Mr. Chatterjee,
28th March.
28th of March.
Is the date. So we have to file our objection. It cannot be before.
File your objection. How much time? Mr. Basu, is it very necessary to file an objection to an Order 7? Why?
As there is a necessity for filing Order 711 in every matter.
Objection is not necessary. Only
Application this is the case.
plaint is there and the also no application is necessary. Also no application is necessary if it can be shown from the plaint itself. So they have filed an application. Objection may not be necessary. I am directing that to be decided.
And my lord, don't make it prior or prior. Let it take its own course. If in the meantime,
But Mr. Basu, if the suit is not maintainable, so prima facie has to be, if they raise a point.
While hearing my lord, the
Prima facie in the court.
While hearing the injunction, court can look into this.
Yes, I am saying that. So if prima facie the court finds no, it requires a detailed hearing of Order 7 Rule 11, the court might prima facie make an observation extent. If the court finds no, at the threshold, court can also reject Order 7 Rule 11.
This is the case in this matter. Partition suit, admitting I am a joint owner, suit is not.
Mr. Basu, I cannot decide that application here and now.
In a given case, the lordship can.
I will decide the suit.
Everything is possible.
This Order 7 Rule 11 means deciding the suit.
27 is
Enormous power.
Anything can be done.
Enormous power.
Don't keep it pending. Let both the applications take its own course. Let us file an objection.
Yes, Mr. Chatterjee. Mr. Chatterjee, you can also make your submission because two senior advocates appearing for one party. So
this is all suggestion. Till such time, Order 7 Rule 11 is not heard out, the interim order will extend.
Eventually, the status quo order has been granted by the learned court. It is in effect till 26th of March. No, Lordship, even the order was extended by the High Court that got expired.
Where is your application under Order 7 Rule 11? Show me that.
Yes, Your Lordship.
Show me your application under Order. Page
614, Your Lordship.
614. What is your ground? Which clause you are invoking of Order 7 Rule 11?
Lordship, B, that is the Lordship cause of action.
Cause of action.
Cause of action. C.
There is no failure to disclose a cause of action.
Lordship, the preliminary point that we have taken in our 711 is that regarding the agreement from which they're deriving the right is not a registered agreement.
Paragraph 4. 4.
Non-joinder of necessary party is a very good ground. If any of the co-sharers is left out.
One of the co-share is left, your lordship. The eldest son in the family.
So that is a good ground for dismissal of a suit for partition.
Let it be dismissed, no problem. Till such time, the injunction should be there. My lord, may I have one? That is here.
But I will not let two
Lord, I should have been here, Lord.
It was
Misunderstanding, Lord.
some other.
Lord, kindly.
Come at 3:30.
Like come at 3. I'll come at 3. At 3:20, Jani. 3:25.
Why?
Today is 3:30.
3:25. Which item?
Lord, 66.
66. 66 টা 3:25.
I'm obliged.
What is the urgency, Mr. Karmakar? You cannot wait till tomorrow.
That's the reason I mentioned in the morning. That's the reason I mentioned this in the morning.
What
Lord,
is the
warrant will be issued tomorrow.
all right? Come at 3:25. Yes. Call the next matter.
31, Your Lordship, Mr. Shonak Bhattacharya is appearing on behalf of the
Since I am not
petitioner.
inclined,
I am appeared for the opposite party. Lordship can direct him to serve copy of the.
yes, please serve him a copy.
I'll in the course of the
Since
day.
I am not inclined to take up this matter on personal ground, this matter stands released from the list of this bench. Let the paper. Yes.
The petitioner is the husband, my lord, matrimonial suit. Thereafter, section 24 of the Hindu Marriage Act. Lordship, kindly come to page after page 45, certified copy. Here, my point is that the present petitioner failed to file affidavit of asset as learned advocate who appeared on behalf of the petitioner, my lord, passed away on that time. So, my lord, I am learned advocate who appeared on behalf of the petitioner, passed away at that time, my lord. My lord, for that reason, I stated, paragraph 6, I have stated the name of the advocate, everything in my petition. So, he did not file, my lord, my affidavit of asset pursuant to the judgment of the Honorable Supreme Court, my lord. So, I am, if your lordship dispose of the application today, that file the, kindly give me
Order
opportunity.
cannot be set aside.
My lord,
this order cannot be set aside.
Then, my lord, here, lordship,
you can apply for recalling on that ground.
My lord, that is, my lord, mandatory to file.
But that you can
that opportunity was given to me. I am, my lord, but that time, my lord, learned advocate.
Yes. So you can apply for recalling of this order since
And
you.
another thing, my lord, I have stated.
I can give you because I cannot give you liberty after setting this order cannot be set aside.
Page 25, my lord, paragraph 7, I have stated in written objection. Kindly have a look into paragraph 7 1 second. Thereafter, my lord.
What are you doing?
My lord, I am a medical representative.
Yes.
And my lord,
what is your salary?
My lord, I have disclosed page 26.
Yes, what is your salary?
27,500.
So how much it has been directed?
My lord, 8,000, but I have to spend 6,500 as a house rent and rupees.
That is neither here nor there.
No, my lord. That is.
Those are not statutory deductions.
No, my lord. That and my mother is a maid servant in the village area. My lord, I reside usually at my workplace at Bardhaman, my lord. My lord, lordship, if your lordship, that paragraph I have stated, paragraph 7, my lord. 6,500 and my lord.
If you want to file affidavit of asset, then I can give you liberty to file an application, appropriate application before the learned trial.
And learned trial, accordingly, thereafter dispose of the.
I will not interfere with this order. I can give you only liberty to file an appropriate application.
And if I file an application, then dispose of that application.
That will be considered in accordance with law.
My lord.
Without interfering with this order.
My
lord. Where have you stated
My lord, for the petitioner, we are praying for transferring of the Act 8 case that is pending before the learned first additional district judge at Barasat to Sialda, as because 498A proceedings, domestic violence proceedings are all pending before
Act 8,
Act 8.
where the minor is staying.
Minor is right now staying under the jurisdiction of inter.
Not right now, at the time of filing of the miscellaneous case.
At the time of filing, the minor was staying under Baguiati PS, which falls under the jurisdiction of Sialda.
Then how can it be transferred? Act 8 proceedings?
Right now, all the matters are now pending before the Sialda.
Maybe.
And in fact, the
jurisdiction, the learned district judge gets jurisdiction.
The opposite party is also, no, Sialda is South 24 Parganas and Barasat is not 24 Parganas. This opposite party is also residing right now at NRS quarters with the minor.
Where are you residing?
I am residing in Salt Lake under Bidhannagar PS.
From Salt Lake to Sialda Court, you cannot come.
I can come.
Yes.
I am having difficulty in traveling to Barasat Court.
This is pending before Barasat.
Barasat Court, man.
Salt Lake to Barasat, how long it takes?
My lord, it is about 18 kilometers.
How long it takes?
18 kilometers. It takes almost 45 minutes. And Sialda Court takes about 10 minutes. 10 minutes.
45 minutes is nothing.
But this lady also has to travel from NRS from Mentally to Barasat.
Let her come.
The problem is she is not being able to come to the court. He is having more difficulties. The matter is getting adjourned on most.
You are concerned. You are concerned for the opposite party.
I am concerned for my matter to be expedited. The problem lies.
It shows you are very much concerned for your wife. Then why is the dispute? Settle it amongst yourself.
I tried.
Both of you stay together. This proceeding will not be there.
Several times I am making
You
regular.
are very considerate towards your wife. It
I am
appears
making regular payments towards my child.
it's not sufficiently. It shows you are very considerate to your wife. Take back your wife. So this litigation will end.
Now, if I try and take back my wife at this stage, another cause of action will arise.
No cause of action.
Another cause of action.
You are very considerate husband.
As per the instructions I have received, another cause of action will arise. And this time the accused won't be the petitioner. He will be the victim. Child is also residing in Baguiati, so it's very, very close to Sialda Court. Very close proximity to Sialda Court.
It's not this jurisdiction, this transfer, this jurisdiction is where the minor is residing. Minor is residing with the mother.
Mother under South 24 Parganas.
Mother is residing at NRS Hospital Doctor's Quarter. So it has to be there. This application.
petitioner is the tenant plaintiff before the Lord trial court.
Tenant plaintiff. Suit for declaration of tenancy right.
Declaration of tenancy, protection of by tenancy.
Yes,
I
but
obtained an order of ad interim injunction. Injunction was subsisting. Defendant landlord appeared before the landed trial court, filed written statement, and with counterclaim praying for my eviction. Lordship, the written statement is annexed.
yes, paying for your eviction. What happened after that?
Lordship, thereafter I've been dispossessed.
You have been
dispossessed by the defendant forcefully.
Yes.
I filed an application under section 151 for restoration of my possession. That application rejected. I filed an application under 39(2)(a) the Code of Civil Procedure for violation and restoration of possession. The learned trial court found I could not file any sufficient material in evidence. That application was rejected. Thereafter, I filed misappeal. Misappeal was
show me the initial ad interim order of injunction.
Lordship, it is at page number
C. Passed by the learned trial judge.
55.
Page
55.
No,
Lordship, I stand to be corrected.
Initial trial court.
Access C. 20. Page number 20, Lordship. It ended in page number 21. The defendants have restrained from evicting the plaintiff from the suit committee whatsoever till 27/2020. Therefore, it kindly comes to page 23. This is the written statement where the counterclaim has been made. At paragraph 15.
What happened after that? Where is your application under section 151?
151 is Lordship at
no. So this
151. I am not challenging the 151 order. I am challenging the order passed in 39(2)(a).
Show me the order under passed under
Lordship at
151.
At page 55. And 151 order, Lordship, at page 48.
151 order as page 48.
48. That in that application, Lordship, at
you did not challenge this order dated 25th of August 2022.
Lordship,
why?
That is, Lordship, I could not, so not challenged. Subsequently, 39(2)(a) was filed, and that order, Lordship, what I must be candid. Before the learned trial court, while hearing the order 39 rule 2A, I could not place this written statement filed by the defendant. That document was not brought into the evidence while disposing 39(2)(a).
Order 39 rule 2A dismissed.
Dismissed. Against that, your Lordship, misappeal was preferred. The dismissal order is at page 55.
But Mr. Haldak, you cannot get back possession under order 39 rule 2A.
I understand, Lordship, but the 151 should have been challenged. Should have been challenged.
Because kindly come to order 39 rule 2A. Disobedience or breach to be property to be attached, the person may be detained in civil prison.
Lordship.
That is the reason for if someone is dispossessed, 151 is maintainable for restoration of possession.
Lordship.
That is the reason.
Lordship.
Because this is penal provision and another is restoration. These two things are different.
But Lordship, pertaining to this 39(2)(a), this punishment, Lordship, what I found from the record, This redistribution statement was not
So
brought
you
in
are
the-
ousted in 2022.
Yes, your lordship.
So what has happened to the suit?
Suit is still pending.
Counterclaim?
Counter
Are they proceeding with the counterclaim?
They are not still proceeding because these proceedings were run.
Have they withdrawn their counterclaim?
No, no, not
That
yet.
is the written statement.
That is at page 23. Annexure D, page 23. It starts from page 22.
But what is the finding of the appellate court?
The appellate court's order is not got into the merit. The appellate court also affirmed the order of the learned trial court. This is lordship internal page number 3 of the appellate court order, impugned order.
Where is the order passed by the learned trial judge in the miss case? An order
That is at
that
page 50. That is at page 55, your lordship. Decision with reasons is at page 56. In this instance, case, the petitioner neither produced any present document nor established his claim.
You have not produced any document.
Admittedly, lordship, this judicial statement was not filed. This judicial statement was not filed before the trial court when this miscase was
Any other document, any complaint?
I filed complaint. My evidence in chief is there, your lordship. Just preceding annexure G, your lordship. My evidence in chief is there. I filed my complaint. Kindly comes to page 58. My evidence in chief. FIR has been lodged. FIR has been lodged.
Mr. Haldar, I think it's better if the suit is directed to be disposed of. Otherwise, what really, because you have not challenged that order of 151. What you will get in order 39 rule 2A? Attachment, will it help putting him behind the bars? Attachment, you are interested in getting back your possession.
Lordship, I am interested in getting back my possession, but
So if
for
you are
the
interested in getting
lordship,
back,
for the purpose, I have to pay.
see what is the stage of the suit?
Injunction has been extended and fixed for hearing of injunction and applications.
Injunction has been extended.
Lordship.
So if your admission is that you are out of possession, how could the injunction application injunction be extended?
That prayer was made and it has been extended. That has been instructed.
You ought to have amended your plaint, Mr. Haldar. After you have been dispossessed,
I need to.
What was the injunction?
I need to pray for getting my possession. Restore my possession.
What is after you have been dispossessed? Did you amend your injunction application
No,
then?
lordship. Not yet. Only if FIR has been made.
FIR is neither here nor there to. It's your complaint.
Police was directed by this Honorable High Court to expedite the investigation, file report, charge sheet. That has not been done. Not been done.
What can be done?
Lordship, can you give us allow me an opportunity to file this judicial statement before the learned trial court in 39(2)A proceeding?
That unless this order is set aside, that cannot be done. So they have to be hard for that.
Lordship,
That is the difficulty. This will be.
Lordship, can you issue notice, direction?
Will that help you? Will that help you?
Lordship, in the meantime, I'll
That is why even assuming that this is allowed, what will happen? Even if the violation is proved,
violation
attachment, civil prison,
it will take it.
You will not get so you will not get back your possession.
Lordship. In the meantime, I will try. I'll
till now you have not amended your plaint.
In the meantime, I will instruct.
Do that. What is in the meantime? Do that fast.
That I will do, your lordship. Petitioner, plaintiff in a suit for declaration, permanent and mandatory injunction. In not accepting the commissioner's report, the application has been filed for division.
Yes, because there is infirmity in the report. He did not specify what method he adopted, fixed points, accuracy, nothing.
Fixed point
in nothing. The court was not satisfied. So rejection of this does not prevent you from filing a fresh application.
My lord, may I be permitted to submit? My lord, kindly, so far the final report is concerned. My lord, kindly page 51. And the commission was held in presence of both the parties. Neither party has raised any objection during the course of investigation works. Evidence was made by the advocate commissioner. He was examined and cross-examined. The question of
show me the evidence of the commissioner.
Yes, my lord.
Page.
Yes, page 43. Page 43. In cross-examination, however, in order to take measurement of any land,
First part. It is not a fact that for conducting survey commission, fixed point is mandatory.
Concept fixed point is mandatory.
Yes.
And then next, however, in order to take measurement of any land, fixed points are to be considered. In page 5, I have stated that I took 2 fixed points. Plaintiff supplied scanned copy of LR measurement.
Show me page 51 or 5.1 of the report.
In page 5, that is, so far the commissioner's report is concerned.
Yes, where is that? Where is the commissioner's report?
Commissioner, with that, page 40 from 45, final report.
45, yes. Page 5.
45, page.
No. Yes, internal page 5. In page, I have stated that I took Two fixed points. Show me that.
Yeah, coming. In page 46, in presence of the above persons, initially I identified the shoot property by the parties. After proper identification, I have started my commission work.
No, fixed point he has taken without any reference to the Moja map. This is not the procedure for holding local investigation.
And he has submitted, he has stated.
He has not verified that fixed points with the Moja map. Can fixed points be taken arbitrarily?
My lord, kindly, in page 51. 51 page.
Yes.
51. It is below portion. It is pertinent to mention here that after completion of commission work, the defendant number 2 supplied a Moja map and a site plan of the suit.
So how he conducted the commission work?
Neither parties are raising no objection.
Nothing. Without Moja map, he has.
Is the husband responded opposite party in the matrimonial suit filed by the opposite party wife And this application is about expeditious disposal of the 151 CPC application filed.
What is the 151 application for?
For seeking for visitation right, my lord. It is at page 10, my lord. The opposite party wife has already filed the.
What is the next date fixed?
It is on 3rd April, my lord.
3rd of April.
3rd of April.
This application under Article 227 of the Constitution of India is
Plaintiff is the petitioner before your lordship.
Yes.
Plaintiff is the petitioner before your lordship. A suit for declaration that the trust deed fraudulently procured from the plaintiff and that is not binding upon the plaintiff. And for the injunction restraining them from.
What do you want?
I'm telling my lord.
Expeditious hearing.
No. In such a suit, my lord, in course of cross-examination, I was confronted with a document that, my lord, I served a notice intending my willingness to donate the suit property to the defendant. I denied in the cross-examination. My lord, the defendant took out an application for appointment of a handwriting expert for comparison of the said handwriting with the handwriting of the plaintiff. My lord, that application was allowed sometimes in 2015. Since there was an inordinate delay, my lord, in the matter of submission of the report by the handwriting expert, my lord, I moved the revisional application before this honorable court. Kindly have a look at page 34.
Yes.
At the bottom, in the aforesaid view of the matter, the learned civil judge, senior division, first court, Barasat, not 24 Gunas, is requested to take all necessary steps to ensure submission of handwriting expert report within 2 weeks from date of receipt of a copy of this order. The learned judge is also requested to dispose of the suit is pending since 2004 as expeditiously as possible without granting any unnecessary adjournment.
Yes. Then
that order was communicated to the learned court below, in March 2023. Kindly have a look at order dated 70.
Yes, what happened after that?
My lord, order communicated, my lord. Thereafter, my lord, they were directed, my lord, to deposit the, my lord, handwriting expert fees. What they did, my lord, they, my lord, deposited before the learned court instead of treasury building. Subsequently, they took out an application for the withdrawal of the said deposit. That has been allowed, but still that, my lord, I do not know, my lord, whether they have deposited, my lord, the fees of the handwriting expert before the treasury building. This order was passed in 2015. Now we are in 2025. Petitioner is an octogenarian. Must they adopted this dilatory tactics, my lord?
Then you have to solve, Mr. Haldar.
My lord.
The learned advocate appearing for the petitioner.
Yes, Mr.
Preliminary objection.
Preliminary objection.
This has become infructuous.
Revision application has become infructuous. Why?
The injunction period has extended to the trial.
Trial court to no.
When? Today. Today is the date fixed.
Has already.
My instruction is, my lord, till now it has not been taken up.
It has not been taken up.
Before the charge court, over and done with.
Maybe.
So, Mitra, there cannot be dispute with regard to this fact.
So that is, I immediately before opening my mouth, my lord, while I was sitting there, I inquired and my instruction was that it has not yet been taken up. It is there for SRAD, nothing further.
My instruction is otherwise. It's gone to the.
In any event, it's an extension. The principal ballot, so far as ballot is followed ballot in case of.
Mr. Chatterjee will say that this issue is pending before the larger bench.
Maybe. Maybe.
So he will take that point because
very well.
He was an architect for this reference. He was the architect of.
Had to be settled, my lord. There was.
He was the architect for this reference.
There were 10 decisions.
I'm not blaming you, Mr. Chatterjee. I'm saying you are the.
Grateful, my lord, your lordship sent it. At least it will come out some way or the other.
Very well, my lord.
There were 10 decisions this way or that.
I said, my lord, I will not take long, my lord. I may take 10 minutes of time. This will not end today. May I, my lord, open? In the meantime, my lord, if required, I shall take further steps. I shall take.
Only one thing, I have fixed one matter at 3:25 because
very well.
There is one urgent matter.
Very well. Now, my lord, kindly once look into.
And if all of you want it to be continued after 3:30, I do not have any objection.
Sorry.
I have no objection, I tell you.
I have. I have. পাগল নাকি না আমি কোনোদিন করি নাই
না তবে 10 মিনিট আরম্ভ করলে হবে
Now kindly take the plaint once, my lord. Kindly come to page 143. I would take your lordship directly to page 152 where the prayers are.
No, what happened? What is the challenge?
Yes, that is exactly why, my lord, I tried to show the prayers in the plaint.
143.
152. The plaint starts at 143. Kindly come to page 152. A decree of declaration that the match scheduled on 13th February by and between the plaintiff and so be decided as cancelled.
This was the objection of Mr. Chatterjee with regard to the name of the club.
Yes.
They needed a Mohun Bagani. They needed a staunch Mohun Bagan supporter to Millard come up before this court to get whatever they wanted to get.
Yes.
That is my main objection.
Yes.
Now, decree for permanent injunction restraining the defendant from declaring the club as champion of the Premier Division of Calcutta Football League. This was the prayer. Now, kindly come to the next document, my lord, the petition, my lord. I would like to place it. I submitted before your lordships that lordship, my lord, on the earlier occasion, that I will try to demonstrate that, my lord, the plaintiff.
Mr. Chatterjee is the plaintiff.
Yes, yes.
Now it has changed. Mr. Mukherjee has come.
Yes.
Yes. So they are the yes.
I would try to demonstrate before your lordship that from the plaint and the petition, it would be evident that the plaintiff did not have any cause of action. Why I shall demonstrate before your lordship. Now kindly come to the petition which starts at page 157. I am showing it from the petition because the petition has the annexures. Otherwise, the plaint and the petition are identical. Page 157, the plaint petition starts. Kindly come to page 160 directly. 160. Paragraph 4. That now the said championship in its last leg and now each and every match is very vital for the teams as an unfavorable result in a single match can change the fate of that team in the said championship. The petitioner is presently standing within top 2 position in the said championship and has a promising opportunity to be the champion in this session. Next. However, due to tight fixture of matches, complaint was tight fixture of matches. Due to tight fixture of matches, the petitioner, it is most unlikely that the petitioner can compete with the best available team in the said championship. One of the crucial matches in the said championship, which is with presently rank 1 team in the said championship, that is East Bengal Football Club, was fixed on 13th February 2025, and the next match of the petitioner in the said championship has been fixed on 18th February. However, on 14th February 2025, the petitioner has to play one of the matches of Reliance Foundation Development League and another match of
another tournament.
Another tournament. I will show your lordship that also, my lord, became, my lord, irrelevant.
Yes.
Whether another tournament or not. So 13th February, 14th February. Complaint is 2 matches on 2 consecutive days. I'll show you, lordship. And another match of I-League on 16th February, which in other words means that within a span of 6 days, the petitioner has to play 4 crucial matches. It is needless to say that the football is a body contact game, etc. Then paragraph 5. The petitioner had well in advance intimated the same to the respondent via letter dated 5th January 2025.
No, fixtures are fixed prior to the starting of the prior to the starting of a tournament.
No.
From time to time.
Yes. Now kindly take note of this date, my lord, 5th of January.
Yes.
5th of January 2025, later of 5th of January 2024, and requested the respondent to reschedule the match dates of the petitioner, which were fixed on 13th February and 18th February. The petitioner also suggested the respondent that the petitioner is ready and willing to play the match with the East Bengal Football Club, which was scheduled on 13th February on either 10th February or 11th February. Now kindly come to this later, my lord, at page 202.
Yes. This is that letter.
Yes. This is the letter. Our remaining matches of the Premier Division of Calcutta Football League has been scheduled on 13th February 2025 and also on 18th February. We would like to inform you that we have a scheduled match on 14th of February, followed by a match on 16th of February. One of them is for the Reliance Foundation Championship and another league. Another one is for our league. For our I-League 2 session this year. As the hours of each other, keeping in mind our existing commitments, we will request these matches as rescheduled to a date which is sportingly feasible for our team to play and perform to its best of ability. Now, this letter, how was it sent?
My lord, is your reply to this?
I'll tell you, Lordship. How was it sent? My lord, it will not appear. It's very important for the simple reason, my lord, 5th of January, this letter they are sending. Now, my lord, in this connection, kindly come to page 207.
Yes.
Kindly see, this is a letter written by the IFA on 12th of February. The fixture for tomorrow's match was provided to you well in advance on 20th January 2025. First line. Page 207.
Tomorrow's match means 13th of February's match.
Yes. So
according to you,
on 5th of January, they could not have written this letter.
So according to you, this fixture was fixed on 20th of January.
Yes. So 5th of January, this letter could not have been written. I know I am not entitled to rely on my documents which are not there on record, but I have annexed.
This is ad interim. This is at the ad interim stage.
I know. I said I know. I have annexed document which will show that this letter of 5th of January was sent by email under cover of an email in February 2020. Again, my lord, that is prejudicial factor definitely, but I do not want to. I'm just showing you that this was the letter. Kindly come back to page 161. My lord, tell me, my lord, when to stop, my lord. I really cannot keep a track there, my lord. No, your lordship wanted, my lord.
Yes. Yes, Mr. Kormakar.
Can
you wait till tomorrow? You cannot wait till tomorrow. Then I have to take, because it is to be taken up prior to 3:30.
Kindly take it up any day. Any day convenient.
How much time you will take?
15 minutes, man. At best.
Mr. Mukherjee, how much time you will take?
We take about 40 minutes, Lord.
40 minutes.
Lord, I tell your lordship, Lord, if my learned friend has not filed his written objection, yet relies upon the documents here for the first time.
No, I am not. I said I am not relying on. I have annexed, I am not relying on.
No, he said that.
Then, Lord, he has to go before the court.
No, I know.
No,
I know.
Mr. Mukherjee, Mr. Mitra started his submission by saying that he is not relying on other documents. He is relying only on the documents which were part of the plaint and the injunction application.
Absolutely.
He is restricting to our traditional view.
Yes, I have to.
Yes.
Any day convenient.
Monday or Wednesday. Monday or Wednesday. Tuesday, lordship is taking up monthly list. কতদিন এক্সটেন্ড করে যে তারপরে তোমার হবে না।
বলছে এক্সটেন্ড করেন।
26 তারিখ কি অবস্থা? 26 তারিখ অনেক কটা আছে? বসানো আছে 27 that is also Friday.
What time?
2 PM বলো। 2 PM বলো।
Can it be 2 p.m.?
3 p.m.
আমার 3:30 হয়ে গেলে
3 p.m. You said
Friday,
15
Friday
minutes.
হবেই।
You
Friday
said 15 minutes. Because Mr. Mitro,
Can I come back at 2:30, my lord?
let me see how far I can progress thereafter. Uh,
I'm grateful. I'm grateful.
one
Well,
word
the
or two
opposite
word?
my lord.
One word or two word?
Grateful. Lord, opposite party, Lord, in a
Mr. Mukherjee, it has been recorded, Mr. Mukherjee, learned senior advocate. So, লিখে দেবেন সবাইকে। Mr. Chatterjee, ask your advocate on record to. Mr. Chatterjee, ask your advocate on record to give. Mr. Mitra, also ask your advocate on record to give the appearance. Everybody's name has been. Don't say that, Mr. Chatterjee.
Lord,
Yes.
the opposite party, Lord, in the district consumer forum is the petition of your lordship. Lord, award has been passed. Lord, the issue is with
Opposite party in the district
consumer forum is the petition of your lordship. Lord, the issue is award has been passed in against me. Lord, against challenging
What is
that
the nature
award.
of the award?
Lord, nature of the award is, Lord, a sale of a vehicle has been cancelled and I have been directed to refund the entire amount. The basis is that the registering authorities are not registering the vehicle for a Supreme Court judgment. Your Lordship knows, my Lord, in 2020, the Honorable Supreme Court had passed an order that from
But this
first
is an appellable order, Mr.
Lord, I understand, but it's completely patent error on jurisdiction.
Maybe.
Not,
From January 16 January 2024, it's an appellable order.
not pay,
Maybe patent.
Lord, kindly seize, my Lord. Your Lordship has argued, your Lordship had argued this, my Lord, had succeeded before Justice Basu. This matter was before Justice Basu. I showed this judgment. Thereafter, my Lord, not this matter, other matter. Kindly seize, my Lord. The proposition was accepted. This was from State Forum. The other side argued that National Commission has the jurisdiction. Justice Basu held that because there was jurisdictional error, that's why this can be entertained. I tell you, Lordship, what had happened here. Kindly, my Lord, comes to
This is not an appellate order. This order was not against appellate order.
this.
This judgment which you are
He said
saying.
this was also an appellate order.
No. This is, you said district forum.
No, this was district forum.
But
This judgment
order
arises
was
out of from
company, I
state.
think, of appellate forum.
This was from State Forum.
So state forum original application or state
No,
forum is
this-
the appellate?
State Forum original.
Where is that? Which
Lord,
paragraph?
I tell you, Lordship. Section 70. The third paragraph, the Learned State Commission by impugned order held that the value of the insurance, since it was 18 lakhs and 18 crores, the commission has no pecuniary jurisdiction to entertain the complaint. The original. This was also, my Lord, an appealable order before the National Forum. Justice Basu also raised the same question, my Lord.
The issue here is.
Have argued as a lawyer is not binding upon
But
me.
this court has upheld this. This court has
But I have
upheld
argued
this.
as an advocate, Mr. Kormokar is not binding.
This court has upheld this.
Yes.
Lord, the issue here is kindly come to Lord page 27 once. The booking of this vehicle was made on October 2019. The sale was completed on February 2020. The Honorable Supreme Court, my lord, passed a judgment by way of which from 1st April 20.
Give me a minute.
I'm sorry. Consumer protection.
Yes, the vehicle is with you.
The vehicle, my lord, is with him. Lord, kindly sees he has taken delivery of possession, page 51.
So then why the
problem is.
What was the value of the vehicle?
The vehicle was, my lord, this
excluding the registration.
8 lakhs. 8 lakhs. Registration value, my lord, we had only charged for certain service charges, nothing more than that. 22,500 as the tax. And for that, we are pursuing for, my lord, this owner in the writ petition.
Have you? What is the jurisdictional point you are raising?
The jurisdictional point is consumer court, my lord, could not have, my lord, gone into this element because registration was never part of, my lord, that particular goods.
That is on merits, Mr. Kormokar.
Lord, kindly comes
this judgment was jurisdiction. Lack jurisdiction on this budget.
Lord, kindly comes to the definition of the goods and when consumer dispute can arise.
That is on merits. Mr. Kormokar, this was on the jurisdiction.
Pecuniary jurisdiction.
Yes.
Lord, here I am. Lord, here I am.
This is an appellable order.
Here I am on only one thing.
There it was on the quantum, whether the district forum or the state forum, it will be there.
I bow down. Lord, the only issue is if there was no consumer dispute. If there was no consumer dispute, the jurisdiction of the district
whether
forum
there
was
was a consumer dispute or not, it's a mixed question of law and fact.
On records, I'll show. On records.
It's an appellable.
But everything is on record.
Maybe.
It's not a jurisdictional issue.
It's an appellable order.
This jurisdictional issue, most humbly, my lord, perhaps is not on mixed question of fact and the only thing, whatever facts are there, Lord, need not be proved because everything is on record. If from the record I can show, I can demonstrate.
Not the case that the district forum lacked jurisdiction, either pecuniary or territorial.
Lord,
So had the jurisdiction to decide,
No, the
but
issue is-
decided wrongly.
no, the issue
according
is
to
inherent lack of
so
jurisdiction.
appeal,
No,
not
I say
inherent
this is
lack.
inherent lack of jurisdiction.
It's not a case of inherent lack.
Kindly comes to a definition once.
Maybe according to you that the petition, the complainant was not entitled to any relief, not an inherent lack of jurisdiction.
But if the consumer dispute is not there, not the consumer forum is
That is
denuded
whether-
of its power
whether
to
there's a
exercise
consumer
jurisdiction.
dispute or not. So it's has to be decided on merits.
So from the records, if I can demonstrate,
Yes,
not from the records.
on the
itself.
records, but on merits. On merits, not a question of jurisdiction.
No,
This
the-
Boj company will not help you.
Lord, kindly considers once, Lord, the consumer dispute definition once. বইটা
কনজিউমার প্রোটেকশন একটা আছে, এটা একটু আনিয়ে রাখবেন। ওই এই বইটা আছে, তো ওইটাতে আছে, সেন্ট্রাল সিভিল অ্যাক্ট আনিয়েছে, হ্যাঁ আছে, দেখো। Yes, which section?
Yes. Lord, kindly comes to 2(8), section 2, subsection 8.
Yes.
Consumer dispute means a dispute where the person against whom a complaint has been made denies or disputes the allegation contained in the complaint. This is what is consumer dispute. Kindly me not comes to complaint.
According to you, registration cannot be said to be a consumer dispute.
A consumer dispute because
But
and
Mr.
why?
Mr. Kormokar, it is your responsibility to get it registered.
Lord, if a third party is involved, if the decision is on the discretion of a third party, Lord, the person who is assisting cannot be made liable. Kindly comes to page 27 once. The disclaimer was given.
Page 27.
Page 27. This is the invoice. Lord, what is the dispute? May I tell your lordship? The dispute is, Lord, the vehicle was booked on October 2019. It was finally.
Show me the disclaimer.
Yes. Page 27.
Yes.
This is the invoice. Your lordship would kindly come to note the terms and conditions. 1, 2, 3, 4, 5, 6. Sixth line, sixth sentence, not from the top. The registration of the vehicle and the issue of the registration certificate is the sole discretion of the registering authority. This disclaimer was there. Today, the registering authority is not registering the vehicle because of the Supreme Court judgment, which is wrongly done. I am pursuing for this complainant in a writ petition. I filed that. Justice Basu wanted me to do that. I did that. It is not my Lord. I will not be benefited in any way if he doesn't get the vehicle. My purpose is only to sell the vehicle. He has no dispute with respect to Lord, whatever Lord, the condition of the vehicle was. He has used it for 6 months.
Mr. Kormokar, you are directed to serve. What happened to that?
Services?
Have you notified them at the time of upgradation? Who is appearing?
Who is appearing, Lord? We
then. It's not for the first time. I was under the impression it's.
Lord, I started by saying Mr. Justice Basu, my Lord, had.
Yes. But there was a direction to serve. And we have upgraded without serving a notice.
Okay. Oh, Lord, mentioning notice was also given.
To whom?
Lord, to the both the parties, to the parties directly. And Lord,
I'm appearing on behalf of the pro forma dispute.
You are appearing.
I
Respond,
testify.
madam. I was
for the bank.
Lordship, just
all right. Pro forma
pro forma
For
dispute
the
was
bank.
recorded. For the
for the
bank.
bank.
A hypothecation. The complainant, my Lord, I find that it's returned as insufficient address. Eta ki hoy?
Then it's not a good service, Mr. Kormokar.
Lord, here we had served upon the advocate also. Pradeep Kumar Giri, I find, Lord, is appearing in the.
What will happen today?
Tomorrow is the case.
Lord, the difficulty is, Lord, tomorrow is the case for warrant.
Tomorrow is
the case fixed, Lord, for final. If not, the warrant will be issued.
Tomorrow it has been fixed before the district consumer forum. So
Order from.
because the other side, Mr.
Lord, I understand.
Because service is not
Lord,
complete.
Lord, here, my Lord,
You have served.
service is complete. But with
You
respect
are
to
absent,
mentioning,
Mr. Kormakar, on the last day.
No, no, matter wrong,
Both sides are absent.
wrong recording.
You did not take any
but
steps.
I'm told you that it's a wrong. I'm told that it's a wrong date.
Cannot be. It was on
On the
25th of
previous
February.
occasion, on the previous
You have
occasion,
mentioned that.
learned advocate for the judgment debtor has not been able to bring stay order. This is on 20th of January 2025. No, this is the previous order. Kindly will not have.
Yes, but on this date you are not present.
No, I am told me that it's
Tomorrow,
wrong.
please, sir, because it was.
But I shall. But kindly protects me from blood tomorrow.
The order of the court. You could resist.
I resist because I said it. I can't remember that I should.
What is your item number?
106.
106 to the.
I done that. Court's order should be complied with. I have done.
There's a point.
But you did not take steps at the appropriate point of time.
Absolutely.
Not take steps at the appropriate.
Absolutely.
File a wrong application without taking
Sir,
proper steps.
What's there? I told them. Plain written statement and 2 decrees. This is all you need in a second appeal. At the point of law. This is a good point why they're avoiding aided school, my lord. Whether he has got a payment or not, my lord, ECL cannot be held liable. It's a division bench of this. And a decree they suffered on that ground. It's contrary to division bench. Lordship knows, my lord, aided school judgment of ECL. Now, give it a down. I have complied. It should have been complied. Well, Lordship gave me the option.
That option was there. Option was there.
Lordship will directly trial court to be lord consider or whatever way again I come back. Because I have filed the plain written statement and the 2 decrees. Records will not be traceable, my lord. It has to be done. I told you. High Court's records are not there of 1990 suits.
Anyone appearing for the other side?
My lord, Lordship didn't direct me to serve. Didn't direct. I asked them. There was no case. Only protects me for that much. And directs the lower court, my lord, to decide my app. I have filed a put up also, my lord, on the 17th of March 2020. Court was insisting.
What is the order under challenge?
Order under challenge, if your lordship takes me, page 8. Put it down. Last page.
Go to the unnumbered.
Give the unnumbered, finally take the certified. The second page of the certified court. Issuance of a writ will. Order 21 will. No further steps will let them come. Their interest is protected. Which are full sum with interest is will secure.